Hi all. Ever had issues writing a judicial precedent essay, focusing on the Supreme Court of England? Or are you looking to expand your knowledge and essay writing skills on the topic? Welcome to the A-Level Law Essay channel, where I will clear your doubts about academic essay writing. In today's episode we're going to be covering the topic on judicial precedent, and discuss the significance of the Supreme Court of England's role in the development of the law. Before we begin, please subscribe to my channel for more video guides on essay writing, and many other interesting topics. With that said, let's get started with part 1 of video guide number 6. Question. Today's question reads, "The Supreme Court of England plays a significant role in the development of the law. Discuss the doctrine of judicial precedent and the ways in which the Supreme Court of England develops the law to meet contemporary circumstances." From the question we can infer that it covers the chapter judicial precedent. And the focus of the question asks us to discuss the doctrine of judicial precedent, and the significance of the Supreme Court of England's role in the development of the law. Introduction. To introduce the doctrine of judicial precedent, we should first start off by mentioning common law as an important source of unwritten laws. This is important, as it can help the reader, or more importantly, the examiner, to understand that the doctrine of judicial precedent is an important part of the common law. With that brief relation, we can now move on to give a brief definition of the doctrine of judicial precedent. It is important for us to only give a brief definition, since this is only the introductory part of the whole essay. The details and further explanation should only be given once we get into the content of the essay. You can say that we should not spoil it for the reader too early in the whole storytelling process. The next important part of the introduction is the thesis statement. Here, the thesis statement should address the question and give both the writer and the reader an idea about the scope and plot of the whole essay. Therefore, the thesis statement should state that the writer will first go through the workings of the doctrine of judicial precedent before considering the Supreme Court's significant role in the development of the law. Point 1. Before discussing the workings of the doctrine of judicial precedent, or even mentioning the Supreme Court, we should first explain the nature and importance of the doctrine. It should be noted that this is an important bridging point between the introduction and the main focus of the essay, as it helps the writer to develop the essay in a holistic manner. This is the part where we have to properly define the doctrine, by mentioning and explaining the maxim to stand by decision, and not disturb that which has been established. Alternatively, we may opt to mention the Latin maxim instead. Or both. It is up to you. Now, if we have already mentioned this in the introduction itself, then we should not cite the whole maxim again, but to shorten the maxim, and then proceed to explain what it is briefly. This is where the importance of the maxim is highlighted by mentioning the saying, "Like cases are treated alike," or that certainty in the law is emphasized, so that order is maintained in place of legal chaos. Something like that. Yeah? Then, we should move on to briefly discuss the nature of the doctrine by considering the elements of a judgment, and the types of precedent. Briefly mention that judgments made by the courts consist of ratio decidendi, which are the main reasons for their decision in a case, and obiter dicta, which are other, unimportant things said within the judgments. The types of precedents are original precedent, binding precedent, and persuasive precedent. Original precedents concern brand new decisions. Binding precedents concern the maxim of stare decisis itself. Persuasive precedents concern any decisions which do not compel the courts to follow. such as decisions made in orbiter, lower court decisions, international court decisions, etc. Point 2. Now that we have made some sense into the doctrine of judicial precedent, it is time for us to discuss the workings of the doctrine, or its practice in the courts, before we can properly discuss its application in the Supreme Court, and how it has contributed to the development of the law. To do this, we should briefly illustrate the structure of the entire court hierarchy by explaining that the hierarchy is broken down into two major parts: the courts of first instance, and the appellate courts. The courts of first instance are at the lower end of the hierarchy, while the appellate courts are at the higher end of the hierarchy. The relevance of this is the fact that the doctrine of judicial precedent works differently for both categories of courts in the English legal system. The courts of first instance are usually bound by preceding decisions made by the higher courts, while the higher courts are not necessarily bound by preceding decisions, as they have the authority to depart, or not follow previous decisions. This is where the relevance of the types of precedents come in. We may briefly mention that binding precedents usually apply to courts of first instance, while original and persuasive precedents apply to appellate courts. It will be good to mention the Supreme Court of England as one of the appellate courts before we move on to discuss about how the practice of judicial precedent applies to it. Point 3. From this point onwards, we will be addressing the second part of the question, that is the significance of the Supreme Court of England's role in the development of the law by way of judicial precedent. To address this, we should first briefly introduce the Supreme Court as the highest appellate court in England, and that it was branched out of the House of Lords in 1999, thereby losing its legislative role in Parliament. To discuss its judicial capacity to develop the law, we should briefly explain the various methods for which Supreme Court judges can use to depart, or not follow preceded decisions and therefore develop the law. This is where judges can distinguish, overrule and reverse preceded cases. A historical account of how Supreme Court judges treat preceded cases should then be illustrated, so as to better understand the judge's role and attitude in the development of the law. We should definitely mention about the case of London Street Tramways v London County Council, 1898, and how Supreme Court judges have decided that certainty in the law was the most important aspect of judicial precedent. Additionally, the historical account of Supreme Court judges in relation to their attitude towards judicial precedent must also be accompanied with the mention of the practice statement of 1966, as this is an important driving factor for which their significant role in legal developments is concerned. Point 4. To further address the second part of the question, some evaluation of how Supreme Court judges actually develop the law must now be considered. This can be done by giving some case examples of how the practice statement is used, and its notion of departure from precedent when it appears right to do so is applied so that laws can actually be seen developing to meet contemporary circumstances. One very typical example would be the case of Harrington v British Railways Board, 1972, and how it departed from Addy v Dumrech, 1929, because of the changing social and physical circumstances as well as opinions. After illustrating how the Supreme Court has used the doctrine in the development of the law, it would be good for us to now give some of our own views, comments, and opinions on whether or not they have played a significant role in the development of the law. Conclusion. Keep the conclusion simple. After all, we should not put in any new points, but to summarize all that we have discussed. So, we should just highlight some of the points that we hold the most emphasis on, and then move on to use it as justification for our conclusion on whether or not the Supreme Court has played a significant role in the development of laws to meet contemporary circumstances. Review. Before we end, let's have a quick review on the content guide. In the introduction, we briefly defined the doctrine of judicial precedent, and how it is a part of the English common law, before we moved on to the thesis statement stating our objective for the whole essay. In point 1, we developed our essay by bridging the gap between the introduction and the focus of the content by briefly explaining the nature and importance of the doctrine of judicial precedent. Points 2. We endeavored to explain the workings of the doctrine in relation to the court hierarchy, and how the types of precedent apply to different courts. Point 3 and 4 is where we addressed the second part of the question concerning the Supreme Court's significant role in the development of the law by explaining how the doctrine is used by it with some case examples to illustrate the court's role. We concluded it by highlighting our justification to the Supreme Court's role in the development of the law. That is the end of the content guide for this video tutorial on the question about judicial precedent. What do you think about it? How would you go about answering it? Do you have any questions? Do let me know by commenting below. Do check out part 2 of this video tutorial, where I will go through with you a sample essay on this question. I will put a link to it in the description below. If you find this video tutorial useful, please like, share and subscribe to my channel for more.